Good evening, everyone. My name is Colleen Peffers. I'm a lawyer practicing in Milton. I'm the principal lawyer at Peffers Law, and I want to thank everyone for coming. I wanted to talk to you about Estate Planning 101, sort of the basics, what documents you need to set up a standard basic estate plan. Not all estate plans are the same. And our philosophy at Peffers Law is to find out what your hopes and wishes are and what you want to accomplish with your estate plan. It's not about filling in boxes. It's about really getting to know our clients and provide them value for the services that we're giving them, ensuring also that their documents are properly completed and witnessed, and that there'll be no issues when something were to happen and they need to be used. Carl, are you able to mute your audio? It's the bottom left button at the bottom of your screen. There we go. Great, thank you. So generally speaking, we have three types of testamentary documents. There's a will. That's the document that comes into play after you pass away. And we usually draft a power of attorney for personal care in case you are unable to make healthcare decisions for yourself, as well as a continuing power of attorney for property. And that when you appoint someone to act in that capacity, that person is able to make financial decisions on your behalf while you're still alive and unable to make those decisions yourself. So the difference is one document comes into play after you pass away, your will, and the other two documents are used while you're alive, but are unable to act for yourself as a result of a mental illness or a catastrophic accident, or maybe you just need help from your kids as you get older and are unable to attend at the bank. It can be used while you're still capable, but it comes into play most often when you are not capable of managing your own property. So who should you appoint? It's often a question I get asked. Do I appoint my spouse? Do I appoint my kids? Do I appoint a friend? And the answer to that question is, who best knows you and is able to make those decisions for you when you're not able to? Because your power of attorney for either healthcare or for property will be responsible for managing your funds and your healthcare decisions. So if you don't have a power of attorney and something happens, someone would have to step up, hire a lawyer, and put together a plan that would be brought to the public guardian and trustee in Ontario. And then the application would have to be made to court, and a judge would have to approve the plan. And then you would have to account for either the healthcare decisions you're making, if it's a healthcare issue, or a property decision, to both the public guardian and trustee, as well as the court on a regular basis, so that there is some oversight in how your funds and how your healthcare decisions are being managed. That burden is very expensive and timely and costly. So legal fees are going to be in the range of $10,000 to $15,000 to get the application submitted and approved by the PGT and then the court. There's an actual court hearing, and they may actually call the person applying to be your guardian to give evidence and or testimony. And then there's a regular accounting that has to be done in a special format. We call it a passing, and that is also is done in front of a judge and approved by the public guardian and trustee. So from our perspective, and many lawyers that practice in this area, your powers of attorney are very important, and they alleviate a lot of problems down the road. Let's say, for example, your son is in a terrible accident, and his wife needs some money, but she's not on the bank accounts and she has no access to funds, and he doesn't have a power of attorney. You really want to be taking care of the illness or the injury rather than dealing with a court application so that that person can take care of their family. So after you pass away, if you have drafted a will, you will have named an estate trustee or an executor. So their role is to administer your estate after you pass away. So they step into your shoes and they basically run a small business for 12 to 18 months, depending on how complex your estate is and how many assets you have, whether you have real property to dispose of. Sometimes we need to apply to the court for a certificate of appointment of estate trustee with a will, if you have one, or without a will, if you die without one. The term certificate of appointment, etc., is basically the same as probate. The terms are interchangeable. A number of years ago, the court decided that they would do away with letters probate and they would now use the term certificate of appointment. We just shorten it. It's a certificate. From our perspective, it doesn't matter if there's a will or not. The application is somewhat similar. So factors to consider when you administer an estate, like I said, it's like running a small business. So when you appoint your estate trustee, they need to have some level of understanding of what your financial situation looks like, where your property is, how you hold it. They are entitled to compensation. There's a guideline within the court structure that allows for 2.5% on the assets coming into the estate and 2.5% on the value of the assets being distributed pursuant to your will. There are reporting requirements, and I often caution my estate trustees to not administer the entire estate on their own. Sometimes it can be quite overwhelming to figure out how you account to the beneficiaries. If the structure of distributing those funds is complicated, you might want some guidance. The law in Ontario has just changed. If you have a small estate, about $150,000, you can ask for a certificate on your own. From our perspective, the process seems quite cumbersome, and it might just be as quick for us to help you with that rather than you trying to do it on your own. And estate trustees do have to report to the beneficiaries. And if the beneficiaries are not happy with the reporting that the trustee provides to them, they can always force that trustee to pass accounts, which is a formal process in court, listing the assets and how the assets have been, consolidated and distributed to the various beneficiaries. That can also be a very time-consuming and expensive process. So what happens if you die without a will? That is governed by the Succession Law Reform Act, and it sets out who can make an application to become the estate trustee and how the funds are distributed. So historically, the first $200,000 of your estate would pass to your spouse if you have a surviving spouse. And then the remainder in excess of $200,000 would be split between your surviving spouse, if there is one, and any children you have. Whether they have predeceased you, it would go to their children or not. The law determines how the estate is distributed. If, for instance, you have a child from whom you are estranged and you wouldn't want them to share in your estate, if you don't have a will, you don't have the ability to have your wishes made known to your trustee or to the court. So, and it is sometimes a little bit more costly for us to help you administer that estate, because if we don't know where all the beneficiaries are, we may have to hire some investigative personnel in order to help locate those beneficiaries, because the trustee must follow the law. There's no bending. So oftentimes people will say, oh, I drafted my will in 1990, it's fine, nothing's changed. Well, many things have changed with the law and some of the language, but your life has changed. You know, your children may be grown now and they don't need a guardian. The person you named as your alternate estate trustee may not be in your life anymore. You may have been married and divorced. You may have had grandchildren that you want to bequeath some money to. Or, you know, there could be have been a change in the identity of one of your beneficiaries or your dependents, or maybe one of your dependents is now receiving some level of government assistance, and there's special provisions that we can address in order to allow them to continue to receive their government benefits without the distribution to them affecting those benefits. So there's lots of times where we feel that you should at least have your will reviewed or any of your estate planning documents reviewed on a 5 to 7 year cycle, because anecdotally, that's sort of when things change. Your young ones go to school, they start school, and then they're out of primary school 7 years later. And then they're out of high school, and then they're out of university, and then they're getting married. So, you know, it's often wise to at least have them reviewed. Maybe you've changed your mind. And, you know, it's always better to make sure that it accurately reflects what you want, rather than assuming that the document you did that you haven't looked at since you met with a lawyer in 1992 to sign it is actually still what you want. So another question I get asked is, I can just fill out a form online and it'll be fine. Well, my litigation practice, our litigation practice has increased probably 300% in the last 2 years with issues where clients are being sued by their children because they don't think that grandma's will was okay. Or the language in the will wasn't clear, or there were multiple wills drafted, which one is the most accurate, or assets were put into a trust and the trust wasn't properly constituted. There's increasing litigation, down to drafting, down to errors that are made by other lawyers, and we've been involved in several litigation files to fix those errors and ask the court for direction on how we distribute the estate, because it wasn't quite clear. So from our perspective, it's really important that we ensure that your documents are done properly and they accurately reflect what your wishes are, and that we take a good amount of notes to our file to ensure that if the will is challenged, we know what you were intending to do, because we've met with you and we've spent time with you. So our standard meetings don't involve us writing down a whole bunch of information. We actually look at your portfolio of assets and we try to come up with a strategy to mitigate the tax and maybe protect assets away from your estate so that they don't attract the tax. There are some things that will always attract tax, like capital gains issues, but we can try and avoid estate admin tax where that option is available to us. So generally, we send you a link to a secure estate planning website, and you provide us with your family tree so we know who your kids are and your grandkids and your siblings. And it also helps us look at your financial information. So we talk about, you know, the value of the home, the debts that you have, how many vehicles you have, what kind of banking do you have? Is it just in a cash account? Do you have investments in an RRSP or a RIF? Because there's ways we can go about mitigating taxes. So we look at all of that information. Then we meet with you to talk about your family and your financial information, what your goals and needs are. And we really ask you the questions: what makes you nervous? What keeps you up at night? You know, do you have a pet? Are you a single person with a pet? What's gonna happen to the pet? So all of those things come out of this conversation. It's really interactive because you are the expert on your financial situation and your family. And we are, you know, the ones with the legal acumen to help put all of those plans and your wishes and goals in a legal document that's going to protect your family going forward. Then we send you draft documents and you review those. And then if you have amendments, we're happy to make those. And then once they're approved, we set up a meeting, we review them again with you, and then we execute your estate plan in front of two witnesses pursuant to the law in Ontario. Does anybody have any questions? I'm surprised that I went through that so quickly. If you have questions, if you want to raise your hand, then I can see you on my little participant screen. Okay, Bev, you're unmuted.
Okay, you can hear me?
I can hear you just fine.
Okay, I have a question.
Sure.
So say somebody calls in and they're looking for estate planning, but they feel very uncomfortable about sharing their bank information, investments, and stuff like that. I run into a lot of people that they just want to get a will done, but they don't want to share any of their personal information, not realizing that it would help them down the road if it was clear what investments they had.
Right. So everything that's provided to our office is highly confidential. We have the Law Society that manages, you know, complaints against any lawyer or paralegal in a law firm working. So the website that we use is secure. It is encrypted and secure. If they're not comfortable providing it to us through that portal, they're welcome to drop documents off to our office, and you know, one of our staff members will take care of that for us. The issue is when you are not honest and upfront with the lawyer that's drafting your estate plan, it's going to cause problems in the future, because when that person passes away and the estate trustee comes in to see us, or the beneficiaries have questions, and we didn't account for a residence that could have been managed without probate, because if you've owned your home long enough, it may qualify for an exemption from probate tax. But if you don't provide us the information, we can't figure that out for you. It might well be that they have RRSPs and they've not named a designated proper beneficiary. They've just left it to the estate. So not only could there be a capital gains issue on the collapse of that RRSP, but it would form part of the value of the estate, and then it would attract estate admin tax. So without an honest, fulsome discussion, there's no real opportunity for us to provide a fulsome estate plan. And we have to be part of the team, right? There's, you know, you've got, when you're dealing with end of life issues, you're going to be speaking to your doctor about what kind of care you want. You're going to be speaking to your financial advisor to make sure that, you know, there's enough funds there for mom or dad or your wife or your son or whoever it is that you are responsible for. And you're going to be upfront with them. So you also need to be upfront with us. Otherwise, we can't really help you appropriately.
Okay, thank you.
You're welcome. Anybody else? No need to be shy.
I think I saw somebody's hand up.
Oh, Warren has a question. Let me unmute. Let me unmute Mr. Strutt. Is Mr. Strutt unmuted? You should be able to unmute yourself, Mr. Strutt.
All right, can I ask a question in the meantime?
Sure,
Push.
Kush. Yeah, absolutely.
Okay. So if I have to do, the estate planning, but I also wanted to do some other setup for my personal, because I'm a business as a realtor. So
Right?
wanted to structure like a trust account, sorry, the trust, and then the holdco, opco, realco, and design the whole thing. And then, within that, do the estate planning and stuff like that. Would you be able to help with those things as well?
Yeah, so outside of the estate planning and the estate admin side, we also run a corporate practice. So I'll tell you a little bit about myself. I was designated as a certified management accountant in 2002. And then when the practice is amalgamated, I became a CPA sometime near my call year. So not only am I a lawyer, but I'm also a CPA. So we have quite a fulsome, robust corporate practice area. And we are now starting to look at the value added for real estate agents that are now able to become incorporated through a personal real estate corporation. So we would talk to you about, what's your what's your estimated annual commission, and does it make sense to shelter that through a prec? And then with a corporate asset, we would definitely suggest that you draft two wills, one to deal with your personal stuff, your home, your car, and then move your personal things, your possessions, the furniture, etc., as well as your corporations into a secondary will. Because if it's in a secondary will, it won't attract tax. It will still attract capital gains tax, which is always,
Mhm.
that is what it is. But we can avoid the estate admin tax on your secondary will, because we don't have to probate those assets. Because when a shareholder or a director in a corp passes away, the corp continues to breathe.
Mhm.
So those transfer of shares can all be dealt with on a paper transaction that doesn't involve the court, nor does it involve the attraction of estate admin tax.
Thank you.
You
Also, one another question for me. Um, is there a way you can set up the structure now, let's say in 2021, and if there is an ongoing, what do you call a court case, or you have sued somebody, somebody has sued you, would your assets be protected, or no, they are not? Because if you're doing the setup today, would it
Mhm.
mean that you are shielding it from now in future, or you can also go back in the past and protect from those things?
So any litigation is going to be subject to the Limitation Act. So generally speaking, it's 2 years from the day you knew or ought to have known that you were injured in some way.
Okay.
So if you set up a corp now, and it was you personally that they were going to attack, they may not know about the corp you have now, but they're going to know, they're going to sue you. And then from that, they'll be tracing to figure out where your assets are or where they went. So, it could be somewhat shielded. It just depends on what the litigation looks like, how old it was, what the value is. Because if there was judgment against you, they're going to deal with all your assets. If you don't
Right.
agree to pay the judgment, then they'll do a debtor's exam and you'll have to list all of your assets.
hmm So they can go after the personal assets that I know, but can they also go against the corporation?
Well, if the corporation wronged them, sure.
Okay, gotcha.
Right? Like
Yeah.
I'm involved in a case right now. It hasn't gone to litigation, but it may well. It's a shareholders dispute. There's two holdcos, two principals of the holdcos, and they formed one big corp. So if I'm going to sue as one of the holdcos, I'm going to sue the corp, and I'm going to sue the other holdco and the person, because it was all part and parcel of the same problem.
If you know about those holdcos and corps, then only. If you don't know it, then you would not.
Yeah, I mean, we do, if in this situation, it's two holdcos with their principals fighting with each other, right? But there's no way to trace who the shareholders are in a corp, but you can trace who the directors and officers are. So, if it was egregious enough, it's possible that they may even sue a director of the corp, depending on what the wrong is. Does that answer your question a bit? Okay, Mr. Strutt.
Yes, thank you very much.
Oh, you're very welcome. You should be able to unmute.
Oh, hi, Colleen.
Hi, Warren.
I'm Warren. Nice to meet you.
Nice to meet you too.
I have 24 questions, but I'm only going to ask 3.
Okay.
So first off, how do you structure your fees for basic wills and estates? Do you have a guide? What's your process?
So we have a standard initial fee for a spousal package, which would involve a will for each husband and wife, or wife and wife, or husband and husband. We don't, a family is a family. And then 2 powers of attorney, 1 for property, 1 for personal care, and 1 for property and personal care for the other. And that starts at $1,750, I think. There's about 6 to 8 hours of time in the file on a standard will package. So it's a little bit more involved than downloading some sort of LegalZoom kit. But the LegalZoom is not going to ask you the questions we're going to ask you. It's not going to ask you how long you've lived in your house. What's your relationship like with your kids? Are they going to fight if you name them as the beneficiary? You've got 5 kids and you want to name all of them. It will be very cumbersome and far more costly for them to administer your estate if I've got to deal with 5 different people in 5 different cities, or not just me, any other lawyer. So it's about the time that we spend with you to make sure that we understand what it is you want, what you want your family to be left with, and no mess. So we're more expensive, I would imagine, than anybody else in town. But I think that we add a lot of value because it's a conversation and it's a relationship. It's a relationship and a team between the client, our staff, my firm, the financial planner, the banker. There may be a property manager if they have a lot of property. So it's about building a relationship that's ongoing, and not just a piece of paper. Because at the end of the day, it's only as good as the ink on it. So for instance, we make sure to include all of your digital assets. If you happen to have frozen medical fluids, we're going to take care of that as well. If there's embryos at an embryo bank, we're going to make sure that that is clear in your documents. And I don't know if LegalZoom provides that option.
Perfect. Well, you did my family's wills and you crushed it. You are the best lawyer that I know. So, I know the quality is there, and yeah, love working with you. I have one more question that I see from in my line of work from time to time, actually more often. And it involves the adding of a child onto the title of mom and dad, or mom and dad's house. What are your thoughts on that?
Those make me really, really nervous. Because if you're an owner, you can force the sale of mom and dad's house. And, mom and dad might want to live in their house until they're carried out feet first. And then it can become quite litigious at the start. I did have one client who knew that dad was terminal, and there was a conversation with dad a few weeks before he passed. And we we did not, because we were acting for dad on the estate planning stuff, we did not go ahead and do the real estate. We sent that out to another lawyer in town. And he put the daughter on as a right of survivor, which is normal when you have a husband and wife, they're joint tenants, and when one passes, the property can pass by right of survivorship without the need of probate or any tax consequences. And the reason we sent them somewhere else is because I was conflicted. I couldn't act to add the daughter and protect my client's interests. So I did advise him that at the end of his life, that was the right thing to do. But if it's to avoid estate admin tax, the risks are high, right? It's high. I would suggest, if they're adamant about it, that there's some sort of life tenancy, that they can't kick them out, that there's some sort of extra document, some sort of contract. It comes up often with cottage properties where they want the cottage to stay in the family. So we will draft a trust agreement that they all agree that this is the way, there's going to be so much set aside from the estate. It's going to pay the operating costs and the taxes for the cottage for a number of years. And then everybody has to put money in the pot, and then they can't sell it. And if they're going to sell their interest, it has to be provided to one of the other beneficiaries that's going to go on title to that cottage, because it can get quite messy. And we're litigating far more now than we have in a very long time. I've got kids suing dads, and I've got brothers not talking to each other, and I've got estate trustees not doing the work and still wanting to take fees. So, and I've been very fortunate. None of the estate planning documents that I've ever drafted in my practice have ever been contested. I'm very lucky. I'm not saying that it's not going to happen, but we've been very, very fortunate. And I think it's because we spend a lot of time with our clients.
Thank you.
You're welcome. Does anybody, there he is. I'm going to lower his hand. Go ahead, Emil.
Hey, can you hear me?
I can hear you just fine. How are you?
I'm okay. Thanks for holding this webinar.
You're very welcome.
I have a question more in terms of, I guess, kind of like a case study, or maybe more of a situational question. I was going to ask that if what happens when it gets contested. A lot of the time, I think when people do a will and power of attorney, they wonder how ironclad is it? What if they have a wife, cousin, brother, whatever you name it, that produces something else? How does that work? And then the other question I had was, it's kind of situational. If you have a power of attorney for personal care, and just wondering, how do the doctors deal with that if it's an emergency? Like if I was a doctor, would I ask for a document if there was an emergency situation? How does that work?
Yeah, they would have to reach out to the next of kin in some circumstance, right? They're governed by the same sort of confidentiality rules that we are. So, if the patient is unconscious, and there's nothing in their possessions to indicate that they're not to resuscitate them,
Right.
then they're going to have to do what they're going to have to do.
Right.
So then what happens is they'll search through the person's possessions and find some numbers and start calling people, unless they happen to be, I know that when I was younger and living in Oakville, we had a little Oakville Trafalgar Memorial Hospital little blue card. So if they found that in my wallet, they would have run it through their system and figured out who my parents were, right, to determine what healthcare, and contacted them. We've been very fortunate that where I have had terminal clients, they have let paramedics know what their wishes are while they were lucid enough to do that. I've had clients take advantage of MAID, the medically assisted aid in dying. And that's quite an arduous process. But their powers of attorney for personal care were drafted in such a way that there was literally no option for the doctor or the attorney to not follow their wishes, because we were drafting for a specific purpose. When you, as a young, man, draft, you're not quite sure what your situation is going to be, right? So it's a much more general document. As you get older or more infirm, we can put better provisions, more ironclad provisions. The doctors are still going to ask the powers of attorney for personal care what it is that the patient wants or wanted. So for instance, it's very important, and we often tell our clients, as much as their kids don't want to hear it, that they need to tell them what it is they want, so that there's no surprises, right? Like in my situation, if my mom would want to be kept on life support, and it's not something I believe in, if there's no hope for her to recover, I would still have to follow her wishes. And it would be hard for me, because I would want her to be at peace, not hooked up, and not the same quality of life. And if it was reversed and she wanted the plug pulled, and I was of the view, let's do everything we can to keep her breathing, those decisions are hard. And that's why it's oftentimes people's block to coming to see us to draft estate planning documents is they don't know who to name. So we sort of help them. We give, I'll say, take out 2 pieces of paper, and on one side of the page, write down all the qualities of the person you think you need to make these decisions for you when you can't. And then on another piece of paper, write down all the names of the people in your life, and then match them up. Because the person who could make your healthcare decisions may not be the right person to manage your finances. And they can be different. And oftentimes it's difficult for people that are single, like myself, who, don't have a spouse, and my mom is going to be 80 this year. Who do I pick? I'm very fortunate that I have and I of course need 2 wills, one for my practice and one for myself personally. And I'm very lucky that I have a very close lawyer colleague who will do all of those things for me and my estate. And we know each other well enough, that he knows what I need and what I want. But, we have these conversations every day. I think sometimes it's hard for our younger generations to hear that mom and dad are going to die and somebody's going to have to take care of that after, or they're going to get sick, and how are they going to manage that work? Because it is stressful. And you don't want to be trying to figure out what mom and dad want in the crisis, because you're trying to keep so many balls in the air that you need to know what they want. And that's why we often encourage our clients to have those conversations with their kids.
Thank you, Colleen. I enjoy hearing you talk about this stuff, because when you speak about it, I can tell there's a lot of empathy. And I think it's very important in these sorts of situations. So thank you.
You're welcome. Thank you. Anybody else? Okay, if nobody else has any questions, let me just check and see. I'm happy to take more. It's not very often you get to talk to a lawyer for free. Come on, Warren, you had 24 questions.
All right, fine. I'll give you one more. So in this COVID environment, what is your practice doing as far as appointments? How does the legal process work? Identity verification, all that stuff. What are you doing?
So we're basically doing the same thing. We have a know your client form. They have to provide us with ID. We check the ID with the Zoom call. So all of that happens before you actually get to one of us, either myself or my colleague, Michelle. So that's all done on the back end. We generally now still do Zoom calls because I've only been vaccinated once. My in-office staff have only been vaccinated once. I have to protect my mom. I have to protect my senior clients. So we do the intake by Zoom call, especially if I've never met the client before, because I want to make sure that there's no weird people in the background telling them what to say, right? Because when they come to my office, I'm checking the parking lot. Because that's one of the newest heads of litigation that we're seeing is undue influence coercion, where those are the allegations being made, you know, son took mom to change your will and the lawyer didn't do a good job. So we still do those queries, right? And I've been doing this long enough that I kind of know when somebody's being abused somewhat. The other thing is when we sign, we used to be able to sign with one set of documents where it would, you know, go around. Now they've taken that away. We have to do it in actual counterparts. So our 22-page wills now become 44 pages or 66 pages if we're not all in the same location. So where possible, we do sign in my office. It's socially distanced. We have very fancy Canadian Tire TV trays that get sanitized after every visit. Beverly takes care of that for us. And we, you know, get you in and out as fast as possible. We thought about, because we have that parking lot beside the building, doing a sort of curbside with a sort of banquet table, but because it's so open, I'm afraid, because we do review the wills with you again, I'm afraid of confidentiality issues. So you come in, we take your temperature, you fill out a COVID questionnaire, we're all masked up. We've got sanitizer everywhere. Hi, Becky.
Hi.
We have sanitizer everywhere. You know, we sanitize the pens, and we've been very, very fortunate to be able to continue this practice. I have done curbside where I've gone to a client's house if they're somewhat local to me, and signed at their homes. I bring my mom as a witness. And then we take them back to the office, Bev prepares some notarized copies, and then we drop them off. But I do take this health situation hugely seriously. We were basically closed to in-person meetings from March till November of 2020. And we would go in and exchange files. And, you know, periodically I would meet with a client. The main office was set up a little differently, but it was always with windows opened and lots of sanitizer. And, you know, because I would feel terrible if I got someone sick. So we are really, really stringent about that. Yeah.
All right, one more question if you'd like.
Sure.
So with most small businesses, if they've got an opco and a holdco, at times there's going to be money going back and forth because that's just how small business works. So it usually ends up through the shareholder loan or intercompany loans. What is the best way to protect a holdco to make sure that if in the event that the opco gets sued, they can't go through the opco to get to the holdco? How do you protect that?
Could probably do it with a GSA, revolving loan agreement, some sort of PPSA registration. We do those quite often.
Okay.
Our corporate practice in the last year has not flourished as much because of COVID, right? My estate admin practice has probably tripled because of so many people passing away.
Yeah.
Not just COVID, but other circumstances, right? It just seems that, you know, and then estate planning is on everybody's mind, especially now that business is starting to open up, right? With this new 3-tier plan that Mr. Ford has put out. You know, people are getting back to work, so there's more free flow of money, and we're so crazy busy now. It's only going to get busier. as people are reintegrating into the workforce, right? So there's going to be more litigation because we've done things differently during COVID and they've not really been challenged in the courts. So I'm expecting, not my firm specifically, but I am expecting to have some, there's going to be some issues with whether or not the documents were executed properly based on it never being done this way before. So that's going to be a problem. And then there's new rules with, you know, a will used to be revoked upon marriage. That has been changed or is in the process of being changed. So things are going to be different going forward. And, you know, there are more people incorporating, and now with real estate agents being allowed to incorporate their businesses, you know, there's an opportunity there to help them do that work with our skill set as well as their estate plans, so that they know everything's protected. They know that the value of their corp is not going to become public if they pass away, because it's not going to get probated.
Awesome. Thank
Okay.
you.
You're welcome.
Great seeing you.
It's good to see you too. I had one question from Nancy. She wanted me to say, what happens if you want to leave $2 to your spouse? Can you do that? So no, you really shouldn't do that. So if a husband and wife are married, there's an obligation as the spouse to make sure that your wife is taken care of, or your husband, when you pass away, because they're dependent upon you, unless you have some sort of prenuptial agreement that pre-decides how your estate is going to be divvied up. So there's two options for that surviving spouse if she's not been properly taken care of in her husband's estate, or her wife's estate for that matter. She can bring a Family Law Act claim, but that expires after 6 months from the date that the deceased passes away. And that looks at the assets of the surviving spouse and the deceased spouse, and it makes like a net family equalization period, as if they were getting divorced. Everybody tallies up their assets and figures out if, you know, how that distribution should go. The other aspect is to bring a dependent support claim. So these are both legal proceedings. If I had a client who was definitely telling me that he was only going to leave his wife $2, I would not draft that will, because I know for sure it's going to get challenged, unless there's some extenuating circumstance because there's a prenup, or there is some level of agreement as between them, some cohab, what have you. Because otherwise it becomes a Family Law Act claim, and that is a problem. Even if he leaves her close, she can still opt into the Family Law Act claim, and if she thinks it's going to be a higher number, even if he leaves her a lump sum. And then the next question is, what advice would I give to someone trying to decide between their entitlement under the FLA and the will? What factors should they take into account? So again, you need to have some level of knowledge of your deceased spouse's stuff. So and you know, I'm hoping that if you've been married a good amount of time, you're going to know what each of you came in with and where you're at now. And it's simply a matter of math. Like any family law file, we used to practice a bit in family, and I practiced that with a calculator. It's, for me, it's not an emotional thing. I know it is for our clients, but it's basically an exercise in calculation. You use the same forms, list all the assets. In one case, we had a spouse that was left not enough money. And they had a joint tenancy on the home, and he severed that. So that's something else that, you know, you can be, that the joint tenancy can be unilaterally severed. So you need to, that's why we ask you about, you know, how do you hold title to your house? Because we want to make sure that we know what the consequences are to how that title is held. Anything else? Okay.
Also, we're on social media now, so you
Yeah,
might wanna-
we're all over social media, which is weird for me because I'm pretty quiet. But I have a go-getter marketing assistant in Jessica and Nancy, and they've been working really hard to make this happen and to create some buzz, and I'm really proud of the work that we're all doing together. And you know, Beverly joined us in January, and Jessica started when? Just recently, May?
Yeah, April.
April, and Michelle started in March. So we are brand new staff, big different attitude. We've got a lot of heart to do this work. It takes special people to deal with death all the time. And we're pretty lucky that everybody cares. So when you call our office, you get a sympathetic ear from all of us, because we've all experienced loss in some way. I lost my dad in 2002, and this is why I do this, because his lawyer made sure that my mom and I didn't worry about a thing after he died. There was nothing we had to do. I had to make 2 phone calls, and that was it. One to him and one to the funeral home, and the rest was taken care of. So mom and I could just grieve. And that's what I want to give our clients. I want them to know that when they leave our office, all their kid has to do is call me and we're going to fix it. That's what we do. Okay. Anybody else have any questions? I want to thank everybody for taking time out of their evening to spend it with me and my staff. It's been great to meet you, and please, if you have questions, let us know. We're always here. Okay.
Thank you very much.
Pleasure. Thanks, Warren. Thanks, Coach.
Thanks, Babs.
Thanks, Emil. Okay,
That's a wrap.
that's a wrap. It's the first one in the can. We'll do them
Good
again.
job. Good job.
We'll do another one. We can do a prep one. We can do whatever you need.
All right.
All right. Thanks, everybody. I really appreciate it.
Night, guys.
Good night.